Good afternoon, everybody. Thank you so much for joining us today. My name is Fiona DiDomenico, and I'm the Regional President with Castle Group, and we're excited to have you here. I wanted to just take a quick moment to tell you a little bit about Castle, and then I'm going to turn it over to Barry, who's going to take us through a phenomenal presentation today. So for those of you that don't know Castle, we are obviously a property management company based here in Florida. We're all across the state. We manage over 400 associations. And one of the things that makes us a little unique is the majority of our associations, we have a team on site. So for the most part, we have larger scale associations, both condominiums and homeowners associations. And a lot of our associations are highly amenitized. And we would love to answer any questions for you. You can reach out to us at info@castlegroup.com. And thank you for being here today. We look forward to answering your questions. And I'm going to turn it over to Barry. Barry, thank you so much for being here today. And if you can tell us a little bit about Osborn Law.
Well, I want to thank first Castle for inviting me to come and speak today. I want to thank the people who are giving us their lunch hour to participate. Both our hardworking managers and those who serve on boards and serve to their community. And Osborn Law is a Florida law firm. We serve condominium and community associations throughout the state of Florida, both in transactional matters and in those disputes which unfortunately come up from time to time between associations and others.
Excellent. Okay, so I think we're going to dive right into the presentation. And just a reminder to our participants, feel free to use the chat function and chat in at any time. I'm going to monitor the questions that I see coming in. And don't worry if your question is up on the chat for a little while. I have seen it. I may just be waiting till we get to the point in the presentation for Barry to address it. But I promise you I'll try to get every question answered that we can. All right, Barry, take us away.
Very good. I'm going to jump right in. And really, this is sort of, for those of you who have attended a webinar or a live meeting back when we actually all used to get together and break bread together, and hopefully those days will come back sooner than later. I've covered meetings. They're a common topic that come up when we do a board certification course or often in our legal update. And what I wanted to do was a little bit deeper dive on this, since we're not going to be covering other topics. And see, I may need to. There we go. So I'm going to go over types of meetings in generals, but we're really not going to focus on the annual meeting or elections, because we all know where the rubber hits the road, where the real work typically gets done is at a board meeting. And I want to focus on that particular aspect of it. And we're going to talk a little bit about the notices that are required, open and closed meetings, quorums, agendas, participation, and then of course the minutes that follow afterwards. So there we go. So just briefly, just to at least cover the topic in a general way, when we have our membership meetings, those are going to be your annual meeting, which is usually commensurate with your election. They're supposed to be tied together, though, of course, in a condominium, the election is independent. So often you may have the voting of 20% to achieve an election, but not actually a quorum for a membership meeting. And then, of course, you may have non-scheduled or special meetings of the membership. When we deal with board meetings, I call them regular or scheduled meetings, and then special meetings. Now, my partner, Christine Ertl, reminded me when we were talking about this, that technically any meeting that is not regularly scheduled through your governing documents, your articles, your bylaws, your rules, is a special meeting. So, for example, you may have in your governing documents a meeting only once a quarter. So technically your regular monthly meetings may be a special meeting. But for the purposes of today, I'm really using special meetings as not just unscheduled, but those meetings where certain activities are going to be considered, such as maybe adopting a special assessment, whether you're going to preserve covenant, whether you're going to adopt rules, that type of thing. Closed meetings. Closed meeting, of course, we're going to talk about is on those circumstances where they're not open to the membership, and the classic would be an attorney-client meeting. An emergency meeting, it's still either a regular or a special, in other words, an unscheduled meeting, but the emergency is going to be one where you don't allow time for notice. And then the fact that we are talking about not just board meetings, but for both condominiums and homeowner associations, certain committees, in other words, if they have the power to take final action, recommend on a budget, they typically have to operate just like the board. So this is important for those who might be, for example, an architectural review committee, hearing committees, things like that, budget committees. So they would operate the same way. So let's talk about the notice requirements. I understand that some of the people who participate either manage or are interested either primarily or only in condominiums and some in homeowner associations. And I know frequently we're told, why are we doing them together? And the reason is not only are many of the laws and rules and regulations the same, but there is hardly a year that goes by. I've been doing this over 30 years, and maybe 1 year I can think of that there wasn't a law, every legislative session they meet, that there wasn't a law that changed condo or HOA law or both. So if there is a law that's in place for condominiums, very often it will later apply to homeowners associations or vice versa. And because the legislative process is a little bit messy, bills typically will cover one or the other or both, and one gets passed, but the other doesn't, and they come back the next year. So a lot of these provisions do change. In general, the condominium regulation is a little bit ahead a few years of homeowner associations because condominiums as a regulated entity have been around longer, and that's just the history of it. So it's still important if you're only interested in homeowner associations. Keep in mind, a lot of these things are going to come back to you as well.
It's a great point, Barry, and often it comes up both with managers and our boards, and they'll say the same thing. And you know what I tell my managers is just because you're managing one or the other, you need to be aware of both, sides of the fence. One, because your residents in a meeting will often raise their hand and say, if it's an HOA meeting, you didn't notice this meeting correctly, for example, and they've Googled something and they've come up with the condo rule. So you have to be aware of both. And oftentimes we will tell our boards, depending on the situation, exactly what you just said. Look, this is likely going to change at some point, or, the higher standard is in a lot of times the condo regulation, and it's not necessarily a bad thing, to follow that suit if it's something the board wants to do. So
it's certainly, and a lot of times you may not have any guidance in the homeowner association world. So we use the condo statute as sort of a reference as to best practices. So it may not be required yet, but it's a good guide as a process as well, just to follow.
Exactly. Yeah, great point.
Let's talk about some of the basics. And for those who are in a managed community, a lot of times you may not think about this because your professional manager's doing it, but the typical meeting of a board is 48 hours in advance of the meeting. And it's specific. It's not a day, 2 days, 48 hours. So, it tells you what they need to do, and it's posted conspicuously on the condo property. And every condominium association should have adopted by rule, or even better in the bylaws, where the official notice is. And some communities may have multiple entrances, things like that. So even though you may do courtesy copies, it's always my recommended best practice to only have one official posting place, because Murphy's Law, maybe you forget to put it in the secondary or tertiary site, and you don't want to make sure that you don't get proper notice that way. So I would want to make sure that you know what are extra copies or not. And the board needs to adopt that rule for specific location for posting. The condominiums, if for some reason you don't have condominium property, and it's going to be really unusual, for example, that you have maybe like a zoning condominium where they're basically single family detached homes and everybody's got a private lot, but it was set up as a condominium. In those instances, you can mail or deliver email in advance, but that's not going to really apply often to most condo associations. By rule, and you can see that this is going to be changed, you can do closed circuit cable. I don't know how many people have like a closed circuit cable. I think we see it when we go into the hotel and we flip the TV on and you get the loop talking about the restaurant, which of course during COVID is closed, and the gym during COVID is closed, and all the other amenities. But that's eventually going to get changed. But you can also, by rule, send out an email with a hyperlink to the website, and you have an option for the website as well. Or now they just added this last legislative year that you can have an application for a phone or a tablet or such on that. And one of the requirements, of course, too, is in condo, which is different than HOA, that's changing, is the agenda. You can't just give notice, but you got to put the agenda out there as well. Was there a question, Fiona?
Yeah, well, we get at that question a lot, which is, can I add something to the agenda, right? So the agenda's been posted and all of a sudden someone goes, well, wait a minute, I wanted to add this, and
That's a real good question. I'm going to come to that a little bit later, but the answer is you can, but it has to be treated like an emergency. So one of the things that we have, and this I think began, I think it's been about 6 years out there. I think it was maybe 1999, relatively recently. And you can see the trend that if you have a condominium of 150 or more units, you are required to put most of your records on the website. And you're required to have either on your front page or a set page called Notice of Meetings and Agenda, a notice page, to put them on there. There's no question in my mind that this trend of moving from closed circuit cable to a web-based notice system is where we are going. And for communities, either HOAs or condominiums that are below that, I think you should anticipate that this is where we are going to, because so much information is now, people's expectation are that it's going to be on a website as opposed to a physical posting.
Yeah, and it really is a good thing. I see it in associations time and time again. The more transparent you can be with everything, and the more, to your point, Barry, having one official posting spot, things like that, the simpler you can make things for everybody to follow, the better off everybody is, right?
Right.
So that just everything on the up and up.
And I think the trend is going to be that the physical location is just as people pick up their mail or drive into the community, that they know, hey, there's something going on, and then they'll go check their website on it as well. Now, when do you need to do special notices? In other words, more than the regular 48. And for condos, it's when you're going to do the budget adoption. And this is important because not only do you have to give them notice of it, you actually have to give them the budget so that they can see it in advance. It's a little different than HOAs that just have to give them notice that the budget is available. You still have to provide the budget. You also, on these things, the notice requirements, you have to document by a sworn affidavit has to be done. When you consider your regular or special assessments, and really when you think about your regular assessments, that's really the second half of the budget. How do you get to your assessment? You take the budget and you divvy it up, but those also need to be done. And one of the things that's important is you have to let people know what the purpose of that assessment is going to be, and what the estimated cost is per unit. And finally, if you're seeking to amend your rules, those are all three areas where you just can't do that 48-hour notice. And it's important because if there's ever something that people are going to complain about or be interested in and really want to hold you to the letter of the law, it's certainly when you affect their money or what they can and can't do with their units. So it makes sense. And so you want to be particular that you meet those requirements. Now,
yeah, very, very important from our end, from management standpoint. Sometimes we'll get a board to say, well, we don't want to, because Castle's guidance is always, especially if you're doing something like special assessment, we want to verify, with the association's, attorney, that everything is, wrapped up nicely, exactly for the reason you just said, Barry. You don't want to go through the whole process and then find out, we misinterpreted documents or statute or something like that. So
right.
We always, clients, let's huddle real quick with the association attorney and make sure we've got all of our ducks in a row so that this goes off without a hitch.
And there are savings provisions in the statutes which say an infirmity of a notice may not invalidate the action, but as somebody who gets in front of a judge and does so regularly, and you're seeking to find somebody or take their home, and the homeowners are there and they're looking at the judge sympathetically, and the judge is expecting the association that you are acting like a government body, and there's really little tolerance that if you haven't followed the law and followed your rules. And that's where the rubber hits the road. In other words, having a rule of people, look, if people just were gracious and kind and neighborly, a lot of these things wouldn't exist. So where you get is people who don't follow the rules and then don't obey the warnings, and that you actually have to get to the point you do the legal process, are the type of people who are, never wrong, always problematic. So they're going to go into court and say, well, they didn't do this and the association didn't do that. And no matter how frustrating it might be that you were living with these behavior issues for months, if not years, the court's going to be looking and say, well, why didn't you give them, 14 days notice? Why didn't you do these things? And the judges have a lot of discretion. So you don't want to give yourself any opening for the technicalities to be challenged. It just makes that that much more difficult to get compliance if it comes that far to a legal dispute. So
we
in a
have
homeowner, before I move to homeowners, want to grab a question, Fiona? Okay.
Yeah, it's on budget meetings specifically from
Sure.
Trevor, and he's saying, so if the proposed budget that got mailed out with the 14 days notice for the budget adoption meeting, if that budget gets changed at the meeting, do they have to send that budget back out to the residents? I think that's what Trevor's asking. Once it has been adopted.
Because the proposed budget is just that, and the whole point of the meeting is that there may be input from people to do so. Now, what I'm talking about is meeting notice. Now, there's a whole separate requirement for having your budget available as an official record, and of course, the budget that's actually adopted, of having the audit compilation or review after the fact to do the analysis. But two different things. What we're talking about in terms is, as a requirement of the budget meeting, you have to have the notice with it. Going back to your point though, earlier though, Fiona, the minutes are going to reflect the final budget that's adopted. And of course, in some cases, it may go to a membership meeting, for example, if they want to waive or reduce reserves or things like that. So even after the board meeting, there may be further matters to be addressed. But to your point with transparency, I certainly would want to, so that people who got the pre-budget meeting later on realize that it's been changed. I think going back to your point of transparency and communication, I would certainly recommend doing that. I don't believe it's required. The requirement is really the condition to the meeting notice, aside from the financial reporting requirements. But you don't have to suspend the budget meeting, send out a revision and go forward, because the point of having it at a meeting is that you very well may make changes based upon the input you receive from your members and other board members. So jumping into the homeowner association world, the posting there is a little different. Condominium property is your common elements, your property. HOA says in the community, because a lot of times you don't have a common element. You have some communities, I know in the introduction, Fiona spoke about a lot of the larger communities that Castle represents and have amenities and facilities. But we have to remember, you sometimes have communities that are what we call pickup truck subdivisions. They may be 6 homes. They may have nothing but a retention pond. They may not even have that. So there, where do you post it? Generally, you can get one of the homeowners to allow you to. You stick it in the street, but you do the best you can, or you can mail or deliver it 7 days in advance. Now, if you have more than 100 members, you can do more like the condo and adopt some alternative methods and procedures as well, but it's the same 48 hours notice. Now, likewise, you have the same 14 days requirement for assessments and amendments to the rules. Now, it's a little less specific than condos in terms of the information that has to be provided. For example, the statutes on HOAs don't talk about that you have to necessarily say what the per unit is, But again, I would do so that people know what is being contemplated. Now, this is a big thing, and it really happened with COVID, and we're still running into it. What about emergency meetings? Well, emergency meetings are two different things. One is the normal contemplated emergency meeting, and then we're going to talk about emergency powers, and they're not the same thing. So when we talk about an emergency meeting, what we are referring to is there a meeting that has to be held with less than the 48 hours notice or less than the 14 days? That's what we're calling, let's call it a condo or HOA emergency. But what about if there's a true state of Florida emergency, a hurricane, a pandemic, things like that? And so I'm using the term for both, but I'll be specific. So let's talk about what we would call a normal emergency or as my daughter would say, a bunny ear emergency. So when we're dealing with that, a little different.
On the top floor of a condominium that, has water streaming down all, 6 floors below it, that would be an emergency board meeting.
Right. So what we're dealing with is HOA and condo are pretty much the same on it, that the emergency allows agenda items to be added. Now, condo is more specific. You need a majority plus one to have the emergency and change the agenda. Whereas on HOAs, they're not specific. So it's my interpretation, it's just a majority of the board. So that's a little bit of a nuanced change between the two. And you have to have the ratification at the next regular board meeting. So let's talk about the bunny ear emergency. What you're dealing with is who decides if it's an emergency, and it's not the management company, it's not the attorney. The decision as to whether there is a matter, like you were saying, flooding, or maybe a legal response is required or something like that, that's a decision for the board of directors to make, that the board has to determine if that is, in fact, something that doesn't allow for full notice. Now, I think it's real important to realize it's not binary. In other words, very rarely is there an emergency that doesn't allow any notice. So what I always remind people is maybe you can't do 14 days, maybe you can't do 48 hours, but I bet you could do 2 hours or 6 hours. So you always want to give as much notice as is practical under the circumstances, because that's what the intent is. It doesn't mean that you give no notice. It just means your notice is less of a time period. Now, I'm going to get into,
I was just say, because a lot of boards will say that, to the managers, we don't have to give notice, it's an emergency. And so thank you for clarifying that.
Right. Yeah. And I do think people miss that. Now, I want to talk about what we would call a real emergency. Now, there's two statutes. In condo, it's 718-1265, and homeowners association 723-16. They're pretty much identical. There's a few changes for the emergency statute because of the condominium multi-story type situation. But pre-COVID, the entirety of these emergency statutes were, how does an association deal with a hurricane? The statutes themselves even talked about cleaning up debris in the mess. Now, when COVID came, and the last thing you wanted to do is get everybody in a room together and have these meetings, there was a question is, could you stretch the interpretation of emergency to cover a pandemic? And the way they were written was dealing with the damage caused by an emergency. It was a real stretch. Now, DBPR's attorney wrote a letter that said that it was within the statute. I think it was a stretch, but then they allowed that letter to expire. So in my opinion, it was a real stretch for that statute to apply. But they came in this last legislative session and they expanded it. So things like a pandemic, those type of things are now clearly within the statute, both condo and HOA. But this is the problem people need to recognize. I know associations still today that are saying, well, there's a pandemic. That's a bunny ear emergency now, and this is why. For it to be an emergency with emergency powers, your city, your county have to be in a state of an emergency declared by the governor of the state of Florida or one of his departments. That's a very particular ruling and administrative order. Those orders expired and have to be renewed. That is not something that the board of directors, certainly the lawyer, the management company, have any discretion in. So if we're no longer in a state of emergency in Miami-Dade, emergency powers do not exist. They don't exist if local government calls it. Now, there's a lot of powers you get in a state of emergency, but that's only during the state of emergency. With respect to meetings, then notices are any practicable matter. You can cancel or reschedule any association. Now, there's broader powers than that in terms of dealing with the emergency response. Who has authority that you can adopt special assessments without the required votes? There's a lot of other powers. But I will tell you now that I've dealt with several communities that are continuing to operate on this sort of COVID emergency that is no longer applicable. So I will tell you how you deal with keeping yourself, your managers, and your membership safe and comply, but it's not by saying, hey, we're just all Zoom, we're just all remote, we're done with meetings, because I don't think that applies today. And I think a lot of people don't understand that. We'll get there in just a minute on that. So I want to talk about the process for an emergency for HOA or such. Now, a lot of times people say to the manager, hey, just notice it as an emergency, and they just go forward on that basis. But to Fiona's point first is, you still got to give the notice that's practical. You can't just tell the manager no notice is required, because that's not what the law says. But then once you have gotten together and you go through your agenda, hey, what notice was given? Do we have a quorum? Because remember, if you don't have a quorum, you ain't a meeting. So once you've gotten past that, the very first motion that should be made, and I will tell you, when I review minutes, I don't see people doing this. You want to do this because it shows two things. One, if anybody ever reviews it, it says, hey, we're not ignorant or thumbing our nose at the law. We're aware of it. And two, in our business judgment, which courts will defer to if you go through the motions, we as a body all agree it's an emergency. And so if anybody challenges it, they may disagree with you, but you've gone through a deliberate process. So the motion that should be is, I move that this proceed on an emergency basis, and what that emergency is, and that the regular notice can't be given. If that does not gain the vote to have that, the requisite vote of the board members, then the meeting is over. You do not move forward. And I think that is so important that people do that. And I just don't see it being done. And now your minutes will reflect it. So later on, if anybody questions it, it should be right there as to why you proceeded the way that you did. So let's go on from there with it. When you get to the meeting, what about voting? And this is important with it. You have a meeting when you have a majority of the board present. That's your quorum. This is really important. Everybody, if you're there and you sit down and you're somebody, I don't want to make this side matter, that side matter, I'm going to sit there and not say anything. It doesn't work that way. It's explicit in condo world. It's implied in HOA world. But in condo world, silence equals an affirmative vote for everything that comes before you. If you want an abstention, you need to formally say, I abstain, and have that put in the minutes. HOA is not explicit, but it definitely is that way. And one of my recommendations on this, and this is a practice I saw some management companies do that I really liked, is sometimes it may be extended time before the motions get typed up, the minutes are done, and the minutes are formally approved. So one of the things I've seen, if you have a very active association, are motion sheets, where the motion is summarized and it's passed around, and every board member there initials it, or if they're not present, the secretary will note by phone or Zoom what their vote is, so that you immediately have a record of where everybody stands. Now, let's talk about attendance. Can you attend by Zoom, by hologram, by any of these magical devices we have, or telephone conference? Absolutely, explicitly you can in condominiums, and it's my opinion you can in homeowner associations too. And you are there just as if you were there in person. You count for a quorum, you get to vote, and so on. Now, what you can't do is say, I can't be there, so I'm going to give my fellow director a proxy and they can vote for me. Can't do that. And you can't vote for email. They clarified that. I never had a question. You can communicate saying, hey, at this meeting, I feel this way, I feel that way about a vote, but you can't cast your vote by email. You have to be electronically live, in other words, in real-time presence. So how do you correlate being there and still have the meeting requirements of having a presence? So let's talk about it. In HOAs, not only do you have to have a physical location, but if you have knowledge that somebody with a disability wants to participate, you need to have it in a location that accommodates their disability. But how do you combine the two? A lot of people say, well, if I give everybody a Zoom link or a phone number, I've met my burden. You have not. You cannot make the Luddites of the world. I have my wife's cousin is a professor at UC Berkeley. He takes great pride in the fact that he has the world's last flip phone. You can't text, you can't chat, you can't photograph. He is terribly proud of this 4-pound brick he walks around with, and he doesn't want to Zoom. So how do you let this highly educated person who's not a technology fan into it? You got to have a physical location. But you're saying, look, we're all afraid of getting COVID and dying. We're unpaid volunteers. We didn't sign up for that. And despite the being compensated, I don't know any manager who signed up, to put their life at risk. I guess you do anyway when you deal with an angry homeowner or their pit bulls. But and anyway, not pandemics. How do you deal with both? And this is how I say you deal with it. You notice the physical location of where the meeting's going to be. And of course, that location, whether you have the 45-mile rule or your bylaws or governing documents, I'm not going to get into that detail. But let's say you have it at the clubhouse. At the clubhouse, the manager or their assistant goes in there, takes the laptop, hits the Zoom link, hits start, has it facing the chairs, or hits the speakerphone. Now, it may be that no human being walks to that location. It's a bunch of empty chairs with the feet. Or maybe my wife's cousin from Berkeley comes in and sits there, whatever it is. But everybody else can still appear by phone. Everybody can appear by Zoom, and they're present. But you've now afforded an opportunity of a physical location. And if you're comfortable being around other people, great, you can go to the meeting too. But if you're not, that's fine too. And I think that's how you blend the two worlds. And there's no reason not to do it. And frankly, there's really no real cost or expense you're dealing with. And some people say, well, we don't have a clubhouse or a facility. Well, unless you have a mileage issue or a bylaw issue, then just have it at the manager's office. In other words, somebody wants to come in their conference room.
And we had lots of meetings. It's one of the, I don't want to say good things of COVID, because that sentence doesn't sound right to me. But one of the things we've learned is what you're describing is the hybrid meeting. And I have to say, across the state, it's been good, right? It's opening it up. More people are attending meetings, and I'm a big believer in, again, transparency. The more you can make it available to people. So to your point, Barry, come in person. We still, in many of the associations, have social distancing rules. Everyone feels safe, and everyone can, join the meeting without any issue. It's been a good thing.
And this is one of the things I want everybody to think about. If you go to an electronic world, in other words, allowing members to attend is not necessary. You could have a Zoom and phone conference for everybody, but make members attend in person, or you can allow members to attend. But you really need to think about it, because sometimes these Zoom chats become crazy. And so how are you going to do it in terms of allowing people's participation? Some people can say we're going to do a hybrid world. And if you want to have a speaking part as a member, you need to appear in person where we control it. Or you may have a different number that's a muted line if you just want to observe. So you need to think about those things, but sometimes it can be harder to control. And certainly I'm not a big believer and worried about whether a non-member attends or not, but for those associations that's a concern, it's much harder to control that in a Zoom or telephone conference world to do so. Now, when do you have a meeting? This is important. When you have a quorum, it's a meeting. And I'm dealing right now in litigation where people said, well, we were drinking beer and out on the terrace. Great. You're having a meeting plus drinking beer and out on the terrace. Now, if you're getting together and you're doing a Bible study, that's great. You're saying, what would Moses do under this circumstance? Fine. But if you start saying, well, what would Moses do with Mrs. Smith's unapproved shed? Now we're dealing with the violation.
Oh, that's a great example. I'm going to use that one, Barry.
And usually people who are involved as leadership in their community, it's hard not to talk about the community. You have a passion, you care about your community, and you're volunteering your time. So you need to really think about it in terms of, and I will also tell you, the appearance of impropriety is an issue as well. When you're dealing with...
Right? No good deed goes unpunished. And it's sad, right, for our board members, because I have the same conversation. They say, Fiona, are you telling me I can't go out to dinner? And I'll, have the same conversation. It's sometimes perception, right, is, do you want to deal with the ramifications of that, right? It's unfortunate, but you got to pick your battles.
Now, it's a lot less onerous now, but these rules, because boards are local government of a sort in terms of the association, but these rules are modeled after the school boards, county commissions, city commissions, the laws applying to them, the sunshine laws, so that you understand the difference. They can't get together even below a quorum. In other words, 2 city council people can never meet and talk about city business without it being noticed, or 2 school board members. So it's a little looser that if you have a quorum, but if you have a board of only 3 people, then it's going to be 2 or more. So you can still meet informally, though. This is something people forget. You could notice a meeting that says 2 or more of the board members are going to get together Wednesday at 10 a.m. at Mrs. Smith's house to talk about the topic. And you can do that. And if other people want to show up and be there, they can be there. So you do have the ability, typically we call them workshops or things like that. So you have a way of complying or not. Now, when you have a meeting, all the rules come into effect for both the board and those committees that are covered. And you should assume that all your committees are covered by the rules unless a lawyer tells you otherwise. Anybody who is there from the membership, not the public at large, has the right to attend and the right to speak, the right to record, the right to video record. They can't be obnoxious about it, but they have the right to do so. Now,
we have a question. The video. Do you want to answer that now on meetings being videoed?
Sure. Yeah.
Okay. So it's from Kathleen, and she says, please talk about videoing and or audio recording condo board meetings. Are they allowed? Is the board able to vote to allow the recording of a meeting, or to not allow? Sorry, is the board able to vote to not allow?
They cannot disallow with it. People are allowed, and this is going to upset some people, that they say, hey, there's a group that has whatever we do, I call it the anti-everything group, and they usually have a Facebook page. And so what they do is they'll take the video recording or the audio recording out of context and republish it. And it drives people crazy. I don't think you can prevent it or limit how people use those things. The thing that I do find that some boards will do is they will ask for people to announce and say, we recognize people have the right to record. We're asking now for anybody who is doing so to please let us know. But you should assume at any of these meetings, it's just like being out on a public street. You're being videotaped and you're being recorded. So I'm not aware of anything that you can do to prevent that. Now, the right to speak is an interesting thing. Some people, unfortunately, don't have enough things positive in their life or outlets, and sometimes participating in these board meetings, and sometimes not in a positive way, is an outlet. So they have something to say about anything and everything all meeting long. And if you are patient people and you don't mind going till midnight, and I had some associations, we'd go to 1 a.m., that's fine. In other words, if that's how the sense of the board is to allow people extra time and more participation, that's fine. But the concept in terms of what's required is it's not a membership meeting. It is a meeting amongst the board for the board. The manager is there to facilitate the meeting, to inform, and often to be the scrivener, the secretary. If the attorney's there or a vendor's there, they're there to simply answer the board's questions or provide information to the board. But it's your meeting as the board members. What is the right of the members to be there? It's just because you're a government body. Their right to be there and speak is because they have the opportunity to lobby or try and persuade you to vote for something or vote against it. So sometimes boards will have a good and welfare or just an open forum at the beginning of the meeting and end of the meeting. That's fine. If you want to do that and you think it's a positive thing to do for community dialogue, great. The statutes for condo and HOA aren't concerned about that. What they require is before you have any votes, you have to have an opportunity of people to speak for that. In other words, a motion is made on that agenda item before you cast your vote. That's when people have the opportunity to speak. And I'll show you how I recommend going through the agenda, but that's the 3-minute minimum that you have to give them. Now, the exceptions, of course, are going to be attorney, client, and personnel. And one of the issues people often get confused with is, well, we want to talk about our CAMS contract or things like that. It's not personal, it's personnel. It means employees. But if they're not a W-2 employee, in my opinion, it's not a personnel matter. That has to be discussed out in the open. There may be some lawyers who disagree, but if you have a manager that is employed by the management company, in my opinion, that's not your personnel. That is the management company's personnel. It's their HR. I think the personnel exception really applies only if you have a direct employee. So, for example, you have a large association and you have a janitor or an engineer who is a direct employee of the association, and there's some allegation regarding misconduct of that janitor, then it might qualify for a personnel or HR meeting because that is the association's direct employee. Let me see. Okay, so I want to walk through step by step how I think the meetings should be conducted. And of course, this is my suggestion. Everybody has their own practice, their own style, but a lot of this is just minimums. Now, first is the call to order, self-explanatory. Establishing quorum, and the notice was properly posted. If it wasn't properly done and you don't have an emergency vote, the meeting's over. If you don't have a quorum, the meeting's over. And a lot of times people just kind of move on. No quorum, no meeting. Approval of the prior minutes tends to be, a standard item. But before you get to that is the amendments to the agenda. This is where the opportunity we talked about earlier, what do you do? Here is where in condo you would need +1, in HOA, a majority of the board to amend the agenda. But remember, if you're amending the agenda and it's a 14-day notice, you would not only have to vote to amend the agenda, you would also have to determine it was an emergency that didn't allow the 14 days notice. So if the item you're adding triggers one of those special events, then you need to do so in that manner. Next are the action items. Now I want to walk through the sequence. If you ever are really bored, back before they had 10,000 streaming Netflix and all, if you were insomniac, you had a choice of watching the loop of the school board meetings or the Ronco rotisserie chicken commercial. Those were your late night TV options. And I'm dating myself. So I've watched a lot of these school board meetings because after you've seen the chicken commercial a half dozen times, you're kind of done with it. But what is contemplated is this: an item is introduced. The manager or whoever is presenting it for the board says, we have 3 bids to perform the landscaping to consider. I have them in your packages, and I'm going to recommend that we hire Acme with it. That's an introduction. It's not all back and forth. It's just, what's the topic? What's the item? At that point in time, anybody who has conflicts of interest should say so on the record. Disclose them. And in condo world, you need to get out of there before the vote. You actually have to leave the meeting. I think it's best practices in HOA world. Now, they changed the rule that they had conflicting statutes in condo that you couldn't ever do a contract with any entity where a board member had any interest, any other 1% interest or more, or anybody within 3 degrees of relation. They've liberalized that. But nonetheless, you need to recuse. But this is where you should disclose conflicts. But now, this is the important part. Let's say nobody on the board is ready to act. I'm the chair of the meeting. I'd say, does anybody have a motion? If nobody does, you shouldn't just keep talking about it. Then you'd say, okay, we'll move to the next agenda item. And a lot of people sort of skip that. So people say, well, how do I make a motion before I've heard everything? This is why. What's contemplated is somebody makes a motion, somebody seconds it. And if you don't have that level of interest, you don't have discussion. But remember, you can make a motion just to get the conversation going. I move we hire Acme. I second, somebody else seconds it. Now it's on the table. I can later vote against my own motion, or based upon what I hear, I can amend my motion and say, you know what, those were good remarks. I like Yellowstone better. I amend my motion to hire Yellowstone. But if you don't have a motion on the table, most people don't follow this, but there really shouldn't be any discussion because there's nothing to discuss. So that's really what's contemplated by Robert's rules. So if you're following Robert's rules, and I understand people may be looser, after the motion is made and seconded, this is the important part. Now the chair turns to the members, the non-board members, and say, okay, is there anybody who wants to speak to this item? No more, no less. Allow them to speak. Then you say to the members, hey, the open meeting's done. We're now going to close discussion to just the board members. Now it's our turn. And now you have the discussion, and then you ultimately have a vote. And every agenda item that requires a vote should roll the same way. And again, with the opportunity of people to speak.
And Barry, if I ask opinion, I know we're getting short on time. It's about, what time is it? 12:48.
Right.
A question I often get on that point is, once you've closed the discussion, the floor for the owners, and now the board members continue to discuss, and then inevitably a resident, a homeowner says, well, wait a minute, now I have another question because of something board member A said. How do you recommend handling that?
If you have a smaller association and you know, it's your time as a board member and you're willing to, you can be looser about it. The law and Robert's rules do not require, and a chair would be perfectly in order to say, Mrs. Smith, we appreciate, but you've had your opportunity already, and this is limited to the board, or you can allow it. Now, if a board member says, I want to hear from Yellowstone's representative again, or I have a question for the lawyer, then properly they'd ask the chair, with the chair's permission, can Mrs. Smith come up because I didn't understand her remarks and I've got a question, and that's how it would be addressed. But properly, unless a vendor or the manager or the lawyer is called upon, everybody else's microphone should be muted. And then if a board member with the chair's permission wants to invite somebody back to the podium or Zoom podium, then they would speak. I realize a lot of times people just sort of blurt out their remarks. And if y'all are okay with that, a lot of times these are your friends and neighbors, and you may only have 1 or 2 active members who participate with the board. I'm not going to say there's anything wrong with it, but you're not required to allow it.
Well, yeah, and I think your point is a great one in that every association is unique, right? So we're giving guidelines here, and where I've seen you sometimes have to rein it in from a management standpoint is when the meetings are lasting way longer than they should, and they're unproductive, and they're starting to create dissension in the community. That's when, as a management company, we sit the board down and say, okay, guys, this is becoming dysfunctional, right? That the meeting is not a positive experience for anybody. Making the residents look bad, it's making the board look bad. We need to get some structure around the meeting and make it more functional.
Exactly. The rules are there so you have orderly business. Sometimes you can give it a little bit more rope, but sometimes when you're dealing with tempers or you have disruptive people, the rules are what are there to protect the process. It's a really good point, Fiona. Let me go, and we're getting towards the end of this, closing board meetings. When you have a closed meeting, and let's talk about attorney-client in particular, you still got to give the notice. People miss that. And a lot of people say, well, why am I inviting somebody to a party they can't attend? It seems sort of obnoxious. You're telling them about it so that they know that this happened on their behalf. And you cannot have action items at these meetings. If, let's say, there's a dispute with the vendor, the landscape vendor, and they're threatening to sue or this or that, you can meet with the lawyer, hear what the risks and concerns are, talk about it. But then whether you vote to cancel the contract after hearing the advice or renew it or not, that has to be done at a subsequent open meeting. The only thing you can do that's of an action item nature may be to give guidance to the lawyer or manager how to act, but you cannot take an official action at the board at a closed meeting. And those meetings, of course, have to be closed to the members. Now, when you're doing a closed board meeting, there's a couple other agenda items. One is, I think for the same reason you have a vote for an emergency, there should be a vote by the board authorizing as a board that it's closed. And if the board doesn't say, hey, we all agree this should be a closed meeting, you stop. Two, you should only talk about the item that was approved to be in a closed meeting. I call it agenda drift. There shouldn't be any. And finally, if you have anybody in that room or Zoom other than the board members and the lawyer and lawyer staff, for example, usually you're going to want the manager there, then you want to have a specific motion that says, hey, we need the manager here because he or she is the only one who knows what's going on and we can't have the meeting without him. But anybody who is in that room other than the board members and the attorney potentially waive privilege. And so you want to be very careful with that. For your minutes, you got to keep your minutes forever now. Your recording meetings, if you do record them until the final minutes are approved in case somebody wants to check it. I do not recommend that you record attorney-client meetings for obvious reasons. You still have to take minutes. Finally, when you have confidential meetings, you still have minutes, but they're kept in a separate location, not available to the members. But on a regular basis, I recommend every 6 months, you should review what are the closed minutes and whether those controversies have ended. So those minutes get moved over. In other words, hey, we have 5 sets of closed meetings. All these disputes are over. I move that they be placed into open minutes. Doesn't mean you have to send them out to everybody. It just means that they would be available to somebody on request. And I think we are landing right within time, Fiona, with a little bit of time for questions. So if somebody wants to take down screen sharing.
Perfect. Yeah, I've got one here right now from Larissa, and it's a great segue from these meeting minutes. So she says, if a meeting is recorded, do the minutes need to be a transcription of the recording?
No, and I think it's a terrible idea. I don't even like recording in minutes that much because let's talk about it. Let's say there's an issue between 2 owners fighting over a fence or something like that. You know, I think it's enough to sort of take the sting out of it because these minutes are on the website. They may be around forever. I don't think you need to say, Mrs. Smith said Mr. Jones is a big fat stinker. Mr. Jones says, well, you know, your dog is ugly. I mean, why do you want to preserve that level of detail? So, you know, years from now, they're still stewing over it. I think it's enough to be on the agenda item. There was a discussion regarding the fence between lot 7 and lot 8. No action taken. I mean, you know, the only thing you really want to record is who was present, who was the notice, and of course, those action items. Anything beyond that, I would put in the minutes only if there's a reason that 5 years later, somebody needs to know that level of detail.
Yeah, I couldn't agree more. And we see it too often, unfortunately, when we bring on new communities where their minutes are literally novels of every, you know, Mrs. Smith was wearing a yellow dress when she stood up at the podium. It's too much. It's too much. So I agree. Another question here from Casey. She says, when ending a board meeting, should a motion be made to adjourn, or can the meeting just be declared adjourned after the agenda is complete?
I think you kind of do in between the two. In other words, if I'm chairing a meeting, I'd say, you know, do I hear a motion to adjourn? No objection, all done. You know, and then the secretary can go ahead and figure out who made the motion or not. You can be a little bit loose with that, but technically, a meeting to adjourn or to recess should be done on a motion and second. If obviously everybody gets out of the room and does, then the meeting was adjourned. I don't know who would ever have an issue with it. In other words, it's not sort of a controversial thing, but technically under Robert's rules, that would be a motion, a second and vote. Though you will see sometimes the chair will say, without objection, and, is everybody approved? And then for the minutes, you would just say by unanimous consent, meeting was adjourned or something like that.
And I agree. You want to just clarify that everyone's said their piece, per se, from the board standpoint. Okay, another question from Glenn. He says, when posting notice of an upcoming HOA board meeting, does the agenda need to specifically state every item that may be discussed, or are more generic topics such as old business, new business acceptable?
Condominiums have more particular requirements for agenda. And there are certain things that we talked about earlier, like assessments or rule changes that need to be explicitly identified, budget adoption. But if I were talking about my best practices, I don't think old business, new business is enough. I think you don't have to do paragraphs, but I think you should talk about what the items are. Now, some things may be recurring business. In other words, under your new business, it might be a monthly report from landscape vendor, things like that. But certainly anything that in advance of the meeting is going to be voted on, in other words, to approve a landscape contract, do things like that, I think should be identified in the agenda for two reasons. One, the board members know what they're walking into, but also if I'm a member of the community, it lets me know, hey, do I want to attend? Is there something of interest there that is important? And one thing a lot of communities don't really talk about is who sets the agenda. And I don't know that we have time for it here, but I'd suggest every board decide, are you leaving that to the manager? Is it the president? Does the manager put anything on the agenda that every board member wants? Or is there some filter that it requires the request of 2 or more board members? So for most communities, there's no real controversy about it, but if you have an issue with these agendas that are driving into 1 a.m. in the morning, you may want to give more thought to how you control what gets on the agenda.
Exactly. No, I couldn't agree more. Okay, another question from Mary Ann. She says, can the condo board use emails as an excuse to discuss issues without having a meeting? I think we already touched on that, but anything else you wanted to say on that?
Well, there is no question. Vote by email cannot be approved. My belief in best practices is twofold. One is everybody who is on a board should have a condo or HOA email account that the manager has access to. That way, all that discussion regarding the business of your community is preserved into an association record and accessible without problem. And two, it's there institutionally when your term is up and somebody comes in, but also that way it's separate from your Gmail or YouTube of your personal business. And if there's ever a owner request to view it or a litigation with the subpoena, you're not having to separate your grandmother's birthday party emails from the association. So I like doing that, but also I don't think there's any prohibition of saying I'm going to vote for this or against this, but I don't think it's the spirit of the law that you predetermine your vote, because you should be open to at least hearing what people may say at the meeting that might change your mind. So you can say anything, but the votes have to be at the actual meeting.
Okay, perfect. Next question is it mandatory to approve the agenda at the start of a meeting, or only necessary to amend an agenda if changes are necessary, as you were discussing? I think the question she was asking is when you were talking about amending the agenda in an emergency situation, she was saying you had to make that approval. But she's saying, do you have to actually approve the agenda at the start of the meeting?
I don't claim specific knowledge under Robert's Rules of Parliamentary Procedure if you need an affirmative vote if the agenda is not being changed. My understanding is it doesn't, but I'm not definitive in that. But certainly the way I normally see it addressed is the chair of the meeting would say, okay, are there, after usually the prior minutes, are there any changes to the agenda? And then if nobody voices it, then you just move forward on the agenda. In my experience, there's not typically a formal vote to accept the agenda unless there's the change desired.
Agreed. Okay, next one from Samuel. He says, I am on a 3-member ARB board. To prep for board meeting, we send packet of info and ask the ARB members to comment or request added information to help make an informed decision. This happens before the ARB meeting. Are we okay? If so, when would we cross the line? Oh, great question.
Okay, it is. One is, just like board members, I think those communications should be done in a manner that the management company has that paper trail. In other words, I like having a email. In other words, email's free now. I mean, whether it's Gmail or Yahoo, there's no reason not to have a special account for that. And if you don't want to check those accounts or add them to your client, you can always have them auto forward to you. So one would be that. Two, I think it's great that people come prepared for a meeting. We've all been to too many meetings and all you do is show up and say, I don't have enough information to make a decision. And sometimes that works an inconvenience to the homeowners that, want a decision made. Where I believe it crosses the line, not legally, I think it's probably legal, but I don't think it's appropriate, is when you actually affirmatively indicate your final vote. In other words, saying, I have concerns with this that would need to be addressed, or this doesn't seem like it's a controversy, fine. But to say, I'm definitely voting against it, I'm voting against it, I think to express a predetermined vote is inappropriate, though I don't think it's illegal, because you would then follow up with the vote at the meeting. I don't think the appearance is proper, because it basically would be like the judge saying at the beginning of the trial, this is how I'm going to rule. Okay, present your evidence. You should at least be open to being persuaded.
Right. Okay. Excellent. A question from Bobby. Are hearing committee meetings open to everyone? I think you just, addressed that all meetings should be. I'm not sure when he says hearing meetings open to everyone.
I'm assuming that this is a meeting where the decision is being made whether to impose a fine or not, or impose a suspension. I would say yes, it's open. When we say anybody, members, or it's my belief that you do not prevent somebody from having the attorney represent them if they so choose, but not to the public at large. But I believe that should be open to everybody.
Yeah. Okay. Next question from Trevor. He says, must a meeting with the attorney regarding litigation, does it have to be a closed meeting? I think most attorneys would say they want it to be if you're discussing litigation, but does it have to be, I think is the question.
Well, I usually do both, and I'll give you a typical example. My personal practice, I do a lot of complex construction defect cases. And the board will meet with me as attorney-client, talk about the case, talk about whether to file suit or not, but it affects everybody's home, their assessments, everybody has concerns. So we will typically do a couple open forums where we won't talk about the legal strategy. For example, you wouldn't go into an open meeting where there's no privilege and say, hey, we demanded the developer give us $1 million, but don't tell anybody we take 50,000. It's like playing poker with your cards face up. It's a disadvantage. But to go into a meeting like that and explain to everybody, this is what the legal process is, this is what the status, this is what the claims are, things that are not privileged in the sense that there's nothing that the other side wouldn't know, that's not a public record, but you're able to present it. We usually do some of that. But if you're getting legal advice, the board members want to be able to speak candidly to each other, not embarrass anybody. It might involve a homeowner's personal situation, to know the strengths and weaknesses, because when you have an open meeting, what it means is if you're a board member and it's not a closed meeting, or you're a homeowner and I can take your deposition, compel you to sit down in front of a court reporter and say, tell me everything that Mr. Ansbacher said at that meeting, or tell me everything anybody else said. And you can imagine it's a real disadvantage if they know what you're doing on the other side. So really good question. But I do believe that there may be circumstances that you have a special meeting to kind of announce what's going on with the attorney present.
Okay, and we've got a few more. We've got 5 more questions, Barry, so I'll try to power through them. I know we're a little over. Discussion of action items. The question is this used for HOA and condo board meetings to start with member discussion? I believe you said yes.
Correct. The same 3-minute rule. In other words, it doesn't mean you have to give only 3. It basically says your rules must allow a minimum of 3. If you're comfortable, you could say 5 or 10 or anything. But my interpretation is yes, condo and HOA, and it's a minimum of 3 minutes per agenda item that will be voted on. If the agenda item is simply, a report of the president or report of the manager, that's not a vote the board takes. So I don't think that you have to provide an opportunity to speak on those type of agenda items, just on voting items.
Okay. Next question from Timothy. Is there a statute regarding who actually runs the meeting? He says, as a CAM, I run most of mine and only have one HOA where the president actually runs the meeting.
Great question. No, there isn't. And Robert's Rules of Order is like reading Beowulf, not the version, when the movie came out and I remember kids telling me, oh, how much they loved the book. I'm like, I still have a headache from trying to get through the old English and understand it. When I was a kid, I didn't realize they turned it into a graphic novel or what I call a comic book. But Robert's Rules of Order is so obtuse and so cumbersome to read. It like gives you a headache to look at it. So there may be something there I'm not aware of, but generally it's understood. And if you look at most governing documents where they talk about it, that the president is presumed to be the chair, or in the absence of the president, the vice president. Though what I have typically seen done with the consent of the board is, as an administration, the president of the board would say, we'd like so-and-so to run through the agenda. I'm not aware of anything that would be precluded, certainly in the statutes. And at the end of the day, as long as the people making the motions and voting are the duly elected board members, I don't have an issue with it. And a lot of times that's something that the experience and comfort with public speaking a manager may bring is a real asset to get through the meetings in a more timely manner.
Exactly. The only time I've ever been challenged, as I think about it for myself, is at an annual membership meeting. So we always make sure, right, that we ask the members, because it's a membership meeting, the board's asked us to chair the meeting. Is there any member, who objects to that? And everyone's like, oh my gosh, no, thank you, right? Like, we don't want to stand up there in front of, 300 people. Please share the meeting for us. So I often see the CAMs do that. Next question is, how soon must or should board meeting minutes be sent to the owner/members for review prior to formal approval at the next meeting?
I mean, the normal process is, of course, is that you would have the minutes typed up and presented, typically if you're meeting on a monthly regular schedule. So when you do either the preliminary agenda or the final agenda, that it goes with it as part of the meeting package of the next meeting tends to be the norm I see. I don't recall ever seeing governing documents that are particular on that. I have seen management contracts where the board has requested or required the management company to provide them in a certain manner because if you have a particularly active association, there are certainly board members who say, look, I want to see the rough minutes shortly after the meeting while it's still fresh in my mind to review. I don't feel like going through and listening to an audio tape or such like that. But I think that's something that should be, I think it should be discussed in terms of what the reason is that you want them, in other words, to have them. Typically, while I don't think they're protected from a request, in other words, if a homeowner says, I want to see the draft minutes and they're typed up, I think they're in a record that's available. But I've never known anybody to publish the minutes until they're approved because they're subject to correction.
Yeah, correct. And I can tell you, we have a handful, if that, of communities that I know that will publish the draft prior to approval, but most associations, their attorneys have guided that, to not do that for exactly what you just said. Well, what if it changes? And then you've got different, sets floating around, et cetera, et cetera. Okay, let's see, where are we? Got 2 left. If a board member is up for election, can they request that owner proxies be sent directly to them?
Well, we're really getting a little bit off topic here in terms of annual meetings and minutes, and those are great topics, but I'm gonna pass on that question because there's a lot of background to that. And other than kind of just giving you the top level saying that there are annual meetings and special meetings of the membership, I'm going to pass on that and keep focused just on director meetings because I really didn't have a chance to go into that in the webinar.
Yeah, no worries. And then last one is from Cynthia, and she says, where can you find the association's role and responsibilities checklist for fining/enforcement committee for an HOA? So I think she's maybe looking for a best practice, which from a Castle standpoint, we have sort of a sample best practice. Obviously, you would have to, check your documents and work with your management, but I can have my team, Cynthia, if you want to reach out and send that to info@castlegroup.com, my team can follow up from our end. Is there anything, Barry, that you have on that end?
There are statutes that talk about the fact that you have to offer people the opportunity. I don't like to call them the fine committee because the independent committee of the board doesn't fine anybody. I consider them the judiciary committee. In other words, the fine is issued by the board, usually through the management company, but the committee, what you're calling a fine committee, is really the people that are there to appeal. If somebody says, I think this is improper, I want my day in court, they're the judges that determine if it was proper or not. So in terms of the procedures and all like that, in my mind, it runs just like any other committee in terms of the notice and things like that. Of course, because of the nature of it, you want to make sure there's meticulous minutes taken and good record taken in terms of that, because it's likely to be scrutinized by a court. I will tell you that because the issue of fines is very controversial, there are always legislators who hear from people who have a sad case of this poor person, was fined all this amount in a sad story. And of course, associations that say we have these horrible renters or people who won't follow the rules and we need enforcement, it gets dealt with a lot. I know that there is legislation that is being considered for the coming January 2022 session to provide greater guidance on the process that you inquired about. So to some extent, I'd say, let's wait and see, but there may be some new laws coming in that area.
Okay, excellent. Barry, thank you. You are, as always, a wealth of knowledge and very generous with your time. And thank you to all of our participants for hanging in there. We ran a little long, but I hope you got some great value out of it. I know I did. I always learn every time I host these things, and I really do appreciate everybody's time. Up on the screen, you can see if you have any questions. Barry's email's there, or you can send it to info@castlegroup.com. We'll make sure it gets to Barry. And we look forward to seeing everybody again in the future for another one of these. I think we could even dissect a few of your slides, Barry, and go deeper. There was a lot of questions, so great job.
Thank you so much for having, and thank you for everybody for participating today.
All right. Bye, everybody. Thank you.